So you or a loved one are in immigration court and you want to know how to defend yourself there. Well, if that's your case, this video is for you. My name is Jorge Molina. I am an immigration attorney based in Dallas, Fort Worth, serving clients worldwide. And today we're going to be talking about three forms of relief in immigration court, which are adjustment of status, cancellation of removal under VAWA, and a waiver under the same law, and asylum. We're not going to go into great detail in all of these forms, but we're going to talk about them and see if they might apply to your case. If you like this video or the content, please hit like, share it, and maybe write a comment on Facebook. Okay, so let's start with adjustment of status. Adjustment of status is pretty much the process by which a person gets a green card. There's certain key requirements for all adjustment of status cases, and there's several exceptions. So there's different laws that apply to certain circumstances. For example, if you're a Cuban national, you have the Cuban Adjustment Act. If you have a family member that filed a petition for you since before April 2001, you could qualify for adjustment status under 245I. And there's a series of other things that you can do, but let's try and keep it simple. And let's talk about the main requirements for adjustment of status. So under the traditional adjustment of status in court, the first thing you must show is that you have a lawful admissions to the United States. Okay, so this means that you presented yourself at the border and you were either admitted or paroled into the United States. So you had to have some procedural admittance into the United States by border officers. So that's requirement number one. Requirement number two is that you must have an immigrant petition immediately available. That means that you have to have a visa available at that point or at the time of filing. So who would traditionally have a visa available immediately? Well, if you're an employee and a labor certification was filed for you years before, that could be one way, and then you maintain your lawful status in the United States during the entire process. Or it was filed before 2001. So that's one group of people. Another group of people are individuals who are married to U.S. citizens or are married to lawful permanent residents for which there's an immediate visa available. Currently, I think most categories have visas available for lawful permanent residents, but that changes depending on the visa bulletin and how many people apply. More on that on the adjustment of status presentation. But in essence, you need a visa immediately available. This means that, say, your brother would like to file a petition and you're a Mexican national. That means that you're probably going to have to wait about 20 years. So in that case, you couldn't do adjustment of status in immigration court. But say your spouse is a U.S. citizen. That means you could potentially ask for adjustment of status in court. And then requirement number three is that you cannot be inadmissible, meaning that all the rules against certain behavior still apply. So if you're convicted, say, of drug trafficking, of over 500 pounds of marijuana, very unlikely that you're going to be able to adjust status, even if there's a waiver available in your case. But it really depends. So that's an important part, right? So lawful entry, visa immediately available, and then not being inadmissible. Even if you are inadmissible, say you have some criminal convictions, say you have possession of marijuana, there's a waiver available for that. So even if you're inadmissible, some people might be eligible for certain waivers. So we have the 212H waiver, which waives certain criminal grounds. So if you were convicted of a quote-unquote crime involving moral turpitude, these are crimes that are considered inherently vile or wrong or involve dishonesty. So for example, you passed a hot check or you stole an item, things of that nature. You would potentially qualify for a waiver if you're also married to a U.S. citizen or a lawful permanent resident. So in those cases, You can do adjustment of status in court with a waiver. All of this is up to the judge's discretion. So it's very important to present a very good case, right? Even if you are eligible. So in other cases, for example, you can do an adjustment of status even if you already have a green card. So let's say you've been a lawful resident of the United States for 4 years, and then you also have a child who's over 21 years old that is a U.S. citizen, and you got your green card through your spouse. If they're trying to deport you and then cancellation of removal for lawful residence is not available to you because you haven't accrued sufficient time, you can request readjustment of status through your other qualifying relative. But that's the key. You must have another qualifying relative that would make a visa immediately available to you. So a child over 21 or a spouse that is a U.S. citizen or lawful permanent resident if there's a visa immediately available for lawful residents. And then under the same category, there's something else known as the VAWA, adjustment of status. So there's two provisions, and VAWA stands for the Violence Against Women's Act. Okay, this is a law that has been in the books since 1994, and every now and then they modify it, they add something else, and but it's been in the books for about 20 years now. But to qualify for VAWA, well, you could file with CIS, or you could also file with the immigration court. Let's talk about the one with immigration first. So for this one, you would have to have been married or be the child of a U.S. citizen or lawful permanent resident and subjected you or your child to severe abuse. So it's either battery, so physical violence, or extreme cruelty. And there's several different things that could be considered extreme cruelty. So for example, limiting someone's ability to earn money, or using someone's immigration status to control them. It's very case specific, but we've seen several cases where those sort of cases are proven that happens. So obviously, if there's physical abuse, that would be a good case for VAWA. But it's not only when you have physical abuse. The key here is that it should have been at the hands of a U.S. citizen or lawful resident that was related to you by marriage or being a step parent or even a parent. Additionally, you got to show that you have good moral character and that you've lived in the United States for a given period of time. If you're eligible for VAWA with CIS, I find that those cases, if you are also in immigration court, those cases are good cases to close in the immigration court if you're eligible for VAWA. However, some cases might not be eligible for protection under VAWA with CIS, and you can only request it with the immigration court. So for example, if you were the victim of abuse, but you divorced the abuser 2 years before applying for the benefit, or the abuser renounced citizenship, so as to when it's time for you to apply, that person is not a citizen or lawful resident anymore. So in those cases, you would be limited to relief in immigration court. And there, you need to, same as in the VAWA context with CIS, you also need to show that you're either battered or subjected to extreme cruelty. The spouse or the parent was a United States citizen or lawful resident, that you've been in the United States for 3 years before applying, that you're a person of good moral character. Again, we have another video talking about what good moral character is, and that you are not subjected to grounds of inadmissibility, and that your deportation would result in hardship. So this standard is actually harder in immigration court than it is in with USCIS. So if you can close your case in immigration court, if you're eligible for this would be good benefit for you. But in some cases, you just, this is the only thing you can do. But again, it's very, very important to prepare your case thoroughly, and know that you still need to show your case even if you show that you're eligible. Additionally, under VAWA, there's another there's a waiver under this law, and it's for individuals who can apply for a green card straight with immigration, but triggered a permanent bar. The permanent bar applies whenever a person is either unlawfully in the United States for over 1 year or is deported and then they re-entered unlawfully. So in that case, for most people, there's no waiver. You have to spend 10 years outside the United States. But if you're a victim of violence at the hands of a U.S. citizen or lawful resident, you might apply for a waiver. But the key is that you have to show that either your departure from the United States or your unlawful re-entry to the United States were related to the abuse. Okay, so right now we've talked about two main forms of relief: adjustment of status, and really depending on your circumstance, different areas of that law would apply. And we've also talked about VAWA and the different waivers within VAWA, and then cancellation of removal in court, if you can't close your case and just get your green card through citizenship and immigration services. And now we're going to talk about asylum. Okay, now asylum is a very complex area of law, but we're going to try to keep it simple here. So when you're in court and you're asking for asylum, it's known as a defense of asylum. So inherently, you are defending yourself against DHS who are trying to deport you. To be honest with you, many times also feels like you're defending yourself against a judge who sees their job as denying your case. It really does depend on the jurisdiction. Some judges are very good, very understanding, but some others, unfortunately, seem to have a closed mind about this. But for asylum, you have to show three characteristics. One, you must show that a person was the victim of persecution or will be if they return to their home country. And the reason for that persecution, item number two, is that they belong to one of the protected groups. So the reason to be persecuted or that they were persecuted is either for religious reasons, their nationality, their race, their politics, or belonging to a particular social group. Additionally, you need to show that the government of the country is the one that's going to do the persecution or is unwilling or unable to stop a group that is going to do the persecution. Additionally, there's certain regulations and rules that you have to follow. So, for example, if you're in the United States, you have about 1 year to file for your asylum application. And you must also raise certain issues and define your group if you're claiming particular social group before the proceedings are closed. So this is another area that, or excuse me, this is another defense you can pursue in immigration court. And importantly here, just bear in mind that it's incredibly difficult. If you don't qualify for asylum, say, because you couldn't file your application within 1 year of being in the United States, you can still request withholding of removal. It's very similar to asylum, but the bar is significantly higher than asylum. And then it results in a deportation order, but they tell the authorities that they cannot deport you from the country from which you claim persecution. So say you're from Honduras and you have a withholding of removal order, they cannot deport you to Honduras. And the benefit of getting this is that you would qualify for a work permit, right? But those are the three defenses we discussed today. We're talking about adjustment of status, VAWA cancellation, and the VAWA waivers, and protection under asylum. So again, if you like the content, please hit like, share, and maybe drop a comment. And again, my name is Jorge Molina. If you think that this might apply to you or you need a defense of immigration court, we'll be happy to assist you and tell you if you do qualify or what we can do. Again, you can call us at 469-708-5800. Again, 469-708-5800. Or you can reach us at info@jmolina.law. Again, info@jmolina.law. Thank you for watching.